On today's webinar, we had three presenters, including myself, and I want to take a couple minutes right now to just give a quick overview of what I spoke about. I talked about Labor Law 203E, which prohibits employers from discriminating against employees on the basis of their reproductive decision-making. And this is not a new law. This actually went into effect in 2019, but there's been litigation around the law ever since then. And there was a recent case that is of some interest, I believe, to employers. But just for some background, one of the provisions of this law says that you must have an employee handbook policy, if you have a handbook in the first place, that explains to employees that their right to be free from discrimination on the basis of their reproductive rights decision making. But a few years ago, thanks to some litigation that was bubbling through the federal courts, an injunction was put into place prohibiting New York State from enforcing that provision. So we were at a point where we, as employers, we were telling employers, you no longer need to have such a policy in your handbook. You can if you want. The law's still in effect. This is still the law. You cannot discriminate against employees based on their reproductive rights decision making, excuse me, but you did not need to have a handbook provision. Fast forward to 2025, where we are now, and we did just get a decision from the Second Circuit Court of Appeals, which is the appellate court governing in New York State, that injunction has been vacated, meaning now employers do need to have a policy in their handbook that explains an employee's right under 203E of the labor law. That is a right to be free from discrimination on the basis of their reproductive rights, decision-making, right, the right to be free of an employer looking at their private information in that area, and a few other provisions. But at this point, the action item, the bottom line for employers is go back, take a look at your handbook. Do you have a provision in your handbook that talks about discrimination on the basis of reproductive rights decision-making? If you do, it's time to add one back in. In addition to my presentation on that topic, we had Nick Jacobson talking about a litigation update, and he talked about the evolution of the legal standard for adverse action in employment discrimination, which is actually pretty important when it comes to trying to defend these claims. And then we had a really practical presentation by Adam Mastrolio that I highly recommend. It talks about paid family leave, retaliation claims, and what that procedure looks like. This is a new type of procedure that just kind of came into effect over the past few years, and we're seeing more of, and he gave a really good overview of what that looks like. So that's a quick overview of the webinar this week, January 14th, and hope you check it out. Thanks for listening.